Sure. Well, welcome to the next session. The internet and technology have changed, as we all probably agree, the landscape on how business owners operate and how consumers obtain goods. And while this new age has some benefits and rewards, it comes with risks and struggles for intellectual property owners, business owners, entrepreneurs, and even consumers. It's not only the internet and technology that have changed how business owners operate, but new emerging markets, as Eric will tell us, present opportunity, but has also become hotbeds for theft and infringement. 20 years ago, a company that intended to manufacture goods or create a technology in one jurisdiction never had to be concerned with what someone else was doing across the world, and that's just not the case today. We are a worldwide economy. On average, just one statistic I looked up before I turn it over to Claire, who will give you more from her study, is that counterfeit goods, pirated digital content, and the theft of trade secrets cost American businesses approximately $600 billion a year annually. So with that, Claire, I know you have some more statistics, and I will turn it over to you. Claire?
Yes.
Go ahead.
Hello?
The stage is yours.
Okay. So, good morning, everybody. I hope the technology will not fail us because I hear myself twice, so it's a bit difficult. So, I'd like to say a few words first about the European Observatory on Infringement of Digital Copyright. It's a European network composed of public and private organizations, as well as consumer and civil society, all joined together in the fight against counterfeiting and piracy. So, and we are part of the EU IPO, which is the European Agency for Intellectual Property based in Spain, in Alicante. So, as we have developing public awareness activities, we wanted first to understand better the audience, and especially the young people, because this is a target group which is more sensitive to IPR. And we ran major surveys back in 2013, and we have repeated it 4 years later in 2017 to assess the perception of European citizens, so all European countries, all age groups. We have interviewed online and by phone 26,000 different people covering all the countries. And we have realized two things. First, the principal perception has not changed. So mainly and mostly European citizens, they are in favor of IP. When we ask them their perception of IP, they are all considering, with a very large majority, that it is very important for creation, for innovation, that we need to have IP protection for rewarding artists and innovators. But when we go down to the personal behavior, we still see a difference. So that's interesting. So we see the picture, now if we go to the first slide, we see the picture for counterfeiting, because we have asked two sets of questions on counterfeiting and on piracy. So if we go with counterfeiting, we've seen that the situation as a bit worsened compared to 2013. So we have 7% of European citizens who have admittedly said that they intentionally bought counterfeit products over the last 12 months. So it's still quite reasonable, but that level compared to into the age group 15 to 24 years old, we see that this is as well double, it's 15%. And the main reason has been declared to be the price. So if they would find more affordable, genuine product, they would stop buying things. So, but if we go with digital content, here the situation has improved. So we have more and more people who are declaring that they are paying to get the digital content through legal lawful services. And this is quite interesting, and it is quite, it has quite improved if we go with younger generation 41%, so nearly half of them, said that they paid one way or another to get legal local services. So, and if we ask them what they prefer, considering there would be an affordable legal offer, they would say 83% said they would prefer to go legal. And for us, it's a very encouraging element, showing that provided there is availability, people would go with legal offers. And this is quite interesting to see confirm this link between availability or non-availability and piracy, and availability and use of legal content. So if we go to the next slide, we see as well the declared accession of pirated content. It's still visible, so it remains stable. It has increased 1 point percentage, so it's quite limited. But nevertheless, we have a good 1/3 of the young generation who said they would go for, they bought, or they went the pirated content online in the last 12 months. So, but what we got as more interesting result from this 2017 study was regarding confusion. I think that's the of the fact well. So we have realized that more and more people are confused, whether it is regarding digital content or regarding physical product. So if we go on digital content, we have 24% of European citizens who are confused about what constitutes a legal or an illegal sources, and it was only 19% in 2013. So, and staying for the checking about the legality of the offers, more and more people have the tendency to check whether it is legal or not. So they are becoming aware that there's a lot of pirated content or unlawful services, and they get more and more the habits to check whether it is local or not. However, they are still getting confused whether it is legal or not legal. And if we go to the next slide, we see the case is the same regarding physical products. So, and here it has quite significantly increased. So in 2017 and 13, we had 4% of European people who said that they have purchased fake products because they have been misled. And in 2017, it was 10%. It has more than doubled. And if we go to the last figure, 35% in 2017 of consumers who have bought a product online and they are not really sure whether it's a genuine product or a fake. So it gives us very interesting insights for launching campaigns, apart from responding to concerns about price availability. So there's quite some ground for maneuvers to developing awareness activities about what constitutes a legal services or an illegal or a fake web shop and a genuine one. Because consumers, especially in the online environment, they are getting more and more confused. And it goes as well with the trend of websites which are more and more developed, well-made, with very close to original websites features, and and consumers are getting more and more confused. So I stop here for the presentation, so I don't want to give you too much information. Of course, the study is a bit longer, so we have more information regarding different age groups. We have questions regarding whether citizens consider IP it is something for them. So very few consumers actually say that IPR or IP protection it's for consumers. They are mainly saying it's for big companies, for famous artists, but it's not meant for consumers or for innovators or young artists. So the study is a bit more complex. We have it on our website, including translation in other languages from the executive countries, and with some infographics.
Thank you, Claire. Thank you so much. Just like the other panel, we're hoping that this one will be interactive and you will ask questions, give us your observations and comments. At this point, I want to turn it over to the other panelists and get their remarks. They come from very different perspectives and backgrounds on IP and theft. So David, I'm going to turn it over to you.
Yeah, sure. So Bruce mentioned a little bit that I'm a performer, songwriter. I'm also an academic too. I teach at the University of Georgia. I teach in the business college. I sort of teach music publishing, public policy, music, economics, finance, etc. So. Excuse me?
They can't hear you.
Yeah, it's on. I'm going to maybe turn it up a little bit. Yeah, I'm just saying that I'm also an academic as well. I sort of wandered accidentally into the music business, and then I actually accidentally wandered into this sort of copyright, IP, intellectual property sort of world by accident. I like looking at this kind of stuff that Claire has just presented. I think one thing that we don't understand, I'll share a little story, or one thing that's not addressed enough is just the effect that even if there are legal services and the majority of the people are using these legal services for music and such, the fact that there remains the threat of piracy, and there's still a lot of piracy out there, unlicensed uses, it drives the price down for copyright owners like myself, like seriously still a market failure. Let me give you an example. I had one leftover song from my solo album in 2009, and I never really knew what to do with it because it's very long and very strange. So last year, and I seem to be the only one interested in it, so last year I just took that one song, it's very long, it's like 23 minutes, and I just pressed it to a CD. At about 11:30 at night, I put it on Twitter and Facebook and sent it to my mailing list, said I've got 1,000 copies of it, that's all I'm going to make, and I just sold it directly to our fans over the next week, right? So it's not like a huge amount of money. I charged $30 for it too. I charged what I thought people should buy it for, So after shipping and taxes and paying for the labor and stuff like that, I netted about $23,000. So here's where you're going to gasp, I hope. So in order for me to make $23,000 about $23,000 on YouTube, I would need about 23 million views of that song. 23 million views, I mean, that is a huge audience, right? How much would an advertiser on a major network charge for 23 million viewers, for each ad? I don't know what sporting events garner, like major sporting events garner viewers on television and stuff like that, but that seems to be up there with that. And that's the problem with looking at just purely legitimate services and the use, consumers using legitimate services and licensed services, is that the threat of piracy has essentially, piracy has caused such a market failure that I don't even think we can really say that we've really made the digital transition yet.
And Eric, you have another interesting perspective.
Sure. So I'm a patent guy, and I'm also a China guy. And as I've told you in the past, if you're a handbag maker or a CD or DVD maker, you probably still hate China. If, on the other hand, you're designing semiconductors, software, or things that take more, manufacturing. China is increasingly becoming a place that you're okay with. And I'll tell you that I went to China originally with Qualcomm and began to see with my own two eyes over the past few years, and especially over the past 2 or 3 years, China go from worst to what I think is first in protecting patent rights in the world. And this happens at a very strange and I guess opportune time for China, because the US has gone from first to among the worst, at least of the major economies. Over the past 10 years, starting with, I guess, eBay, that basically over the last 10 years has developed into a principle that you can't get an injunction no matter what the situation is. China, you're basically guaranteed to get an injunction if you win your case. We're talking like 99% of the time. Combine that with the fact that the litigation lasts between 6 and 12 months, hovering around the 10-month mark for major cases, including a foreign party. The fact that it doesn't cost but maybe $250,000 to $500,000 to litigate a case from start to finish in China. And even damages, which in the past have been sort of miserable, are changing. And my prediction is within the next 18 to 24 months, we're going to see our first 100 million US dollar damage award in addition to an injunction. And the injunction's the magic in China. It's because not only can you get an injunction on sales in China, which is either the #1 or #2 market in most areas. In smartphones, it's the #1 market, and soon it's not even going to be close. But keep in mind that China is still also the world's manufacturer. And unlike other law that generally provides an injunction only for imports, China also provides an injunction for exports. So, Apple's not a client of mine, so I like to pick on them. Plus, I used to work at Qualcomm, so that's another good reason to pick on them. And so let's take Apple. Still right this second. I know they're building a manufacturing facility in India. Good luck with that. I've worked in India too. Because they make 100% of their iPhones in China right now, if, for instance, Qualcomm or anybody were to get an injunction, again, if you win, you get it about 99% of the time, you get to basically cancel their worldwide supply chain. And in fact, they've actually talked about this in a brief in the Northern District of California regarding a spat that they had with one of their suppliers, BYD, which in addition to now being a car company and producing everything, much like a lot of Chinese companies, also produces batteries, and that's what they were using that for. Basically, in a public brief, look it up, it's Apple versus BYD. In a brief, they basically spell out the parade of horribles, saying that their worldwide supply chain will be destroyed in a Chinese patent litigation. For those of us that value patent rights and are looking for some place to go, given that the U.S. has decided, we'd rather have Google than patent rights, China's a good place to be. I'm sorry about, the brand stuff. We're getting better, but it's one of those things. And my parents would roll over in their graves if they knew, #1, I'm working for a Chinese law firm, working in Beijing, and advocating that China is now the leader in IP rights, at least as relates to patents. I know how weird that sounds, but it is absolutely true. And the last thing I'll point out is why. Because in China, you have to think about the motivation for everything. In China, right now, from the top down, President Xi, about 2 or 3 months ago, gave a speech where he said that damages for IP infringement, and that actually includes brand and copyright, needs to increase. And this is an impetus because China wants to, surprise, surprise, rule the world as it relates to technology. And the only way that it's going to do that in China's mind, there's those people, maybe some in this room, that say, but patent rights don't help innovation. Tell that to China, because they're betting everything on it. That's why they've created the best patent enforcement system in the world, because they believe that a number of things, including getting their own market, let's face it, they now have a market to protect. So all of a sudden, out of nothing over the past few years, they've created this IP system, this enforcement system. But it's also ingenious because it allows Chinese companies to come to the US. For instance, Xiaomi. I have a Xiaomi phone. I also have an Apple phone. And Xiaomi is, I think no secret, likely to come to the US in the near future in terms of its phones. It also makes a whole bunch of really cool appliances for a fraction of the price.
And also the streaming.
What's that?
And also the music streaming service. I believe.
Yeah, I mean, it's an amazing company, and I won't go into it, but Xiaomi is coming to the US, and before the rise of China as a patent rights power, the first thing that would happen if Xiaomi came here would be Samsung and Apple would file a patent infringement lawsuit, and Xiaomi would be stopped. Now, my advice to Xiaomi is, yeah, you get a few patents in the US just because it's good to fire back, but the real reaction should be immediately file a case in China and put Samsung and Apple out of business worldwide, and then compete on the business, which is what I think Xiaomi and the folks that don't have these huge market advantages. The panel before this pointed out that a number of things, but what I would say is that these companies, for instance, in a lot network, they don't need patents because they have market leverage. Patents are for those folks that are the up-and-comers, the innovators. And somebody's going to yell at me about this, but Google used
I'm waiting.
Google, I told you this. Google used to be innovative, everything they did. I mean, they were, the little guys loved them. It's not like that anymore. A lot of their acquisitions, they kill the technology, not incorporate it. The point is that patent rights are important, and China sees that, and China's smarter than anyone. And they do things at the speed of light. I'm not going to opine on their method of government, human rights, or anything else, but because of their system of government, they can make a change immediately, and the impact happens the next day.
Thank you. Judge Rader, your thoughts?
Couple quick observations. First is Eric is correct. IP leadership no longer resides in this country. It has shifted to Asia, primarily China. I advise many large clients. I was given the option to file 6 cases last month, anywhere in the world that I wanted to go. We filed them in Guangzhou. For the reasons that Eric pointed out, and a few more. China's no one's largest market. It's everyone's fastest growing market. And any businessman will tell you that's your most important market. You control your markets through the rate of change. So Eric has stated really well a lot of the dynamic that's going on. Now, if we quizzed him for a moment, we could find out that there's a dark side to every point of leadership. There's a landslide of utility models and designs that are of vastly low quality, but they're addressing that. And the additional little point I would throw in is that I spent last week at a conference at my university, Tsinghua. And at Tsinghua, we had a conference on creating a Hatch-Waxman system, a pharmaceutical balancing protection system for those of us who don't live in the pharma world. And in attendance were 10 judges, including 4 from the Supreme People's Court, at my invitation, and they come instantly. And the enthusiasm for creating what will be a litigious system. The interesting point of Hatch-Waxman is that it uses litigation as a public policy tool. It encourages litigation. And yet, they see this as not a bad, but as a part of the meaning of intellectual property and its proper administration. On our interesting counterfeiting and copyright points, I reflect on my classes, again, taught at Tsinghua to 50 students, and I asked the question, after showing some statistics like this, would you buy counterfeit goods? And particularly my young ladies say, absolutely not. Well, why not? Has nothing to do with any of the IP. It's that they can quickly recognize that it's counterfeit. And I said, well, I look at those bags, they look identical. Oh no, they can show you 3 or 4 details that identify it as a counterfeit good, and they wouldn't be caught dead carrying a counterfeit bag. I think that's more true in the Chinese market even than the U.S. market, isn't it, Eric? Yeah, you and I spend a lot of time there.
Yeah, I think it depends on the city and the person.
I think that's true.
Gaudy bags or
I'm
something.
sure that's true too, Eric. There's, as I say, for every point of good emphasis, you can always find a counterpoint. But I do think this conference needs to grapple with a global market where the implications of our policy choices are not national. Well, they have their national consequences, but they tend to shift the competitive advantage elsewhere. And right now that's being taken up quite aggressively by Asia. See Seagram here. Europe is responding to this. They're creating a unified court system. They've recognized that they have fallen into a less competitive mode, and they feel a need to catch up. I don't hear quite enough talk of that nature in the USPTO or in any of these academic conferences. We have a certain glib confidence that we're in charge. Guess what? We're not.
Thank you. Claire, do you have any comments based on what you heard?
Sorry?
Let me stand up and actually talk to you. Based on the comments that you heard, do you have anything you want to add about the statistics or what the gentlemen have said so far?
I wanted to pick up on something regarding you mentioned the quality, the last intervention regarding the quality of products and fakes and the global markets. That's true because we have been seeing more and more, and this is common from enforcers and consumers, that the quality of the goods consumers are buying and which are fake, sometimes it's quite difficult to distinguish the fake from the genuine. The quality of the fakes are increasingly good. And I don't talk only about luxury goods or clothes or shoes, but as well things which is quite difficult to distinguish if you're a consumer and not a specialized company checking this, like electrical equipment or automotive parts or electrical appliances or things which sometimes, and they are really, really faking the packaging and pretty well. So there are avenues for exploring into new technologies to help consumers distinguish these things, and really supporting better understanding and better analysis of the quality of the products and making sure they get the originals. And especially us in the observatory, we are looking into new technologies such as, for example, blockchain, or understanding a bit how the supply chain can be secured to reassure consumers that the track and trace systems in place make them sure that what they have in the end is a genuine product. So I don't know if anybody would like to pick up on this technology point, because it's we are more and more into this discussion, and we see quite some potential to address these issues as well.
Does anyone have any comments based on what Claire said? No. Does anyone in the audience have any questions for the panelists? Otherwise, you have to listen to all my questions. I have a lot, but...
David, this is targeted for you. So
Okay.
in copyright, there's this concept of a mechanical royalty, ringtone and other things like that.
Right.
And there's no analog in the patent space, so I'm not suggesting that there should be, because the individual value of the invention can vary. But from your first-hand perspective, has that mechanical royalty ever been worth it, number one? And number two, is there an analog here that is usable in other forms that might lower the enforcement value of other IP types, IP patents, if there was a guaranteed floor or rate structure in place?
The mechanical royalty, goes back to the 1909 Copyright Act. 2 cents for each mechanical copy of a song, which was player pianos and maybe gramophones. Then it stayed at 2 cents until 1976. And then it eventually rose to 9.1 cents. And it's been at 9.1 cents and will remain at from 2009 to 2021, I think. Rates are set by a panel of administrative judges in the Library of Congress. There has been all kinds of shenanigans, like sort of, they have to examine some evidence of market rates. But there's been sort of these, what seem to be constructed deals between two parties that are then submitted as evidence. It's frankly a nightmare. I can kind of understand it when the United States, you have millions of writers and millions of users of songs, and mechanical royalty provided some market efficiency in 1909. We don't really have that today. I mean, we could have there's a lot of blockchain enthusiasts. I think they're crazy, but they are pointing out the fact that we could have, some kind of global database to, immediately license and exchange fees for works and stuff like that. The mechanical license, which pays the songwriter, has largely been it's been subject to so much lobbying. Like, the songwriters have a very difficult time arguing against these very powerful digital near monopolies that use our music. I have a feeling that rate is going to be stuck again at 9.1 cents for the foreseeable future, if it in fact doesn't go down. Now that's on copy. Streaming, the copyright royalty judges gave us 10.5% of gross revenues, which in a way wasn't necessarily a bad idea, but we didn't envision that these services would come out and just give them our stuff for free. And then it's been kind of nightmare. It's not a floor, though. This is the point I wanted to get at. It's a ceiling. So if you think the minimum wage sucks, try the maximum wage. Okay? So, yes.
The closest thing to that in the patent field would be a patent pool, where you'd have a mechanical sharing of royalty revenues across a group of pool members. And with the exception of MPAA, they haven't been, excuse me, yes, very important. They haven't been vastly successful. I remember approaching several of the standard-setting organizations and suggesting that they might initiate some kind of a pool arrangement and set a royalty as they issued the standard. They were very reluctant to enter into a rate-making process.
Well, while we're talking about standards, I think that's another real issue, in my opinion, problem facing all nations right now. If, again, my personal view, if you have the foresight to come up with a technology that's so good, efficient, cheap, and innovative that a standard-setting organization sees fit to adopt that as what everybody should use, you would think, as long as you share that you have patents on that technology, that that patent should be more valuable than other patents. In reality, they're far less valuable in today's world. I won't go into that other than to say that China, again, is, other than the UK, the rest of the world sort of penalizing SEP owners. China, on the other hand, at least, we've had one case where the question of can you get an injunction on a standard essential patent, and that was IWIncom against Sony, and the answer was a resounding yes. We don't know too much because IWIncom is a very favored Chinese company, and Sony is a Japanese company, which is, politics really don't get into the patent cases that much, but if you couldn't get an injunction in that case, you probably couldn't get an injunction in any standard essential case. So at least it's looking not horrible.
Bruce, I think did you have something to add?
No, next question.
Oh, there's another question from the audience.
And my question is principally for you and perhaps Judge Rader. I've been very critical of the eBay decision, but to play Google's or devil's advocate, I repeat myself, what's wrong with the following argument? I'm Apple, I open up a semiconductor fab facility in China and it cost me $1 billion to do it. Then someone comes along with a method of manufacture patent, and it's a real patent, I infringe it, maybe it helps me produce a couple more chips an hour, so the patent's worth $1 million in terms of increased productivity. But for me to design around, now that I've already sunk the $1 billion into my facility, would cost $100 million. So an automatic injunction allows the patentee to extract potentially 100 times the value of their patent. So it's not a worthless patent, it deserves something, but taking your advocacy hat off for a second and putting your social policy hat on, isn't it just as wrong to grant an injunction 99% of the time when you have a significant fixed cost investment problem, which I've just highlighted, just as it's wrong in the United States to automatically say that you don't get an injunction under the eBay regime?
I think that you should address it in terms of how this is likely to play out. So let's take the Qualcomm case. I'm not predicting this in any way. But let's say Qualcomm wins their infringement case. What's going to happen is that then there's going to be hearing or series of hearings where the judge is going to have to decide whether, and this may be after the appeal, but whether Qualcomm would get their injunction. And here's where I think the question is answered. The way it's likely to happen in China is that the judge will talk to Apple and say, Qualcomm, and one of the things that you need to do in China is up front, come up with, if you're a plaintiff, if you're a patent owner, exactly what it will take to make you not happy, but go away. And if you don't do that, the courts will punish you, and probably rightfully so. In the US, we have a tendency to hide the ball as long as possible. You can't do that in China. So the judge will say, okay, well, Qualcomm, what do you want? Qualcomm should say, well, in the beginning of this case, in our pleadings and in various hearings, we said we wanted X. Apple has tried to destroy our very business, put our patents at issue, blah, 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 and we've offered 1X number of times, and then we offered 1.5X. At the end of this case, when we've already won, we ought to be able to get, I don't know what it is, like 3X, 5X, maybe as much as 10X. It's not like 1,000X or, 1,000,000X, but it's probably going to be something along the lines of, the Panduit kicker has been, debunked for many years in the United States, despite the fact that it makes perfect sense. If you decide that you don't want to pay the parking meter outside, and then you get a ticket, you can't go to the court and say, well, I'm ready to pay my $1.50 now. That's sort of how it goes. So what's going to happen is then Apple will get a chance to say, well, and the judge will ask Apple, are you okay with 3X? Apple will say yes or no. If they say yes, problem solved. Transfer of funds and life goes on. If Apple says no, then there's likely to be an injunction, and I think that addresses the fairness issue.
Your question presumed misvaluation of the invention. In one sentence, get the valuation right, the injunction issue goes away. I think that's what Eric said. He just said it a little more specific.
And we're long-winded. Remember, I'm an attorney. Maybe not in China. I'm a consultant, but.
I think there's some more questions up there, and I think there's also one down here. We have about 5 minutes left.
Josh Lathrop. Capitalism is a foundation of the United States of America. And we've talked a little bit earlier today about startup companies and the role of IP in capital formation in the United States. I would like it, particularly Eric and Judge Rader, if you could speak to the role of the increasingly important patent system in China and the role of capital formation in China.
Sure. Apple is no longer the second largest handset producer in the world. That now belongs to Huawei. Huawei invests deliberately more than 15% of their revenues in research and development each year, and then turns to me and yells at me to make sure we protect that. But they also have one building, a mile long in Shanghai, and there, Eric, I'm sure, with 50,000 engineers in it, doing nothing more than inventing 5G, where I think they're ahead of Qualcomm in their investment and their production. The brief answer is, everywhere I look in the technology community, there's a significant investment by Chinese companies in R&D based on their faith that they can protect it through IP.
And I would agree with that 100%. Full disclosure, Huawei is a client, so I better say that. The other thing is that, this whole capitalism, go to Shanghai, go to Beijing, go to Shenzhen, go to Guangzhou, go to, like the top 10 cities. Go to a small Chinese city where the population is only 10 million. And those cities are going to be far more capitalistic than any city in the United States. You don't say capitalism in China because they don't like that. You say market-driven, and somehow it's okay. And the reality is that capitalism is alive and well in China. Capitalism is, price, supply, demand, and profit. China is very capitalistic in the way it does business. It just moves at the speed of light. It's not like the government is deciding who gets to win. In the past, there have been local governments that have tried to do that. In the past, the Congress, in the last week, the party decided and warned local governments that they don't get to pick winners anymore. It's going to be based on who's the best. And China has some of the best technology companies, whether it's Huawei, Xiaomi, Tencent. I mean, the apps on, like WeChat, yeah, it copied a whole bunch of technology, but then it made it better, and it's far better than anything we have in the U.S.
Hey, Eric, I don't mean to stop you, but I think there was another question down here, and I know we only have a couple minutes left. There's a few. Did you still have a question?
Well, on the issue of the Apple factory in China question, when I spoke to my former student, who I identified to you when we were talking before, and who was general counsel of a major American pharmaceutical company, what he told me is when the major American pharmaceutical company sues a Chinese infringer, the judge basically says to the pharmaceutical company, if you demand a reasonable royalty, I will force the infringer to pay.
You're 10 years out of date. That's exactly right, 10 years ago. You know where the best place for an alien, a foreigner to win a case in the world is? China. 67 out of 67 cases by foreigners were won by the foreigner in the IP court in Beijing last year.
Okay, there's another question over here. Right there.
Which, by the way, is an indication of weakness as well as strength. The reason we won 100% is because we only filed slam dunk cases. We didn't trust the system enough to give them the same variety of cases that we would file here in the U.S. I'll be much happier when those win rates in China come back closer to 50-50.
Go ahead, sir.
I have a question about the same issue, but a slightly different aspect. Namely, the technical, in particular in IT technology, engagement of China is well known, and it's a nightmare for most Western companies. Are we going to see the same problem in biology technologies? It's a quite different world that if we put it concretely, you know, you're building one mind now which works in DNA research. Or is it still the American domain? And will it remain the American domain?
I can specifically, I don't know everything. I'm not a pharmaceutical guy, although my firm certainly does pharmaceutical. What I can tell you is that most of the research regarding cancer in the world is being done in China. And, you know, even if China isn't at the top of, you know, the world game, wait a year. It will be. Yeah. What
What are their products?
What are the products?
They're producing blockbuster drugs as a result.
No,
Right,
No.
right.
not yet.
No.
That is very correct. They have 6,000 generic companies, there are 6,000 pharma companies, most of them generic. Probably about 4,000 of those are traditional medicine rather than Western medicine. But they're the country that is increasing their protection for branded drugs through this new Hatch-Waxman system, with the president himself saying he wants 35 new chemical entities produced by a Chinese inventor next year. That's not likely to happen, but they're emphasizing.
And follow
Hey,
up.
Bruce has a comment over here.
What do we need to do in the U.S.? How do we correct the situation? How do we improve it for us?
How do we improve our situation? Well, this is still the biggest market in the world. This is still where everybody has to do business. They're just doing it, as Eric pointed out, by using an injunction in China to accomplish the desire of controlling the U.S. market. We still have every opportunity to retain that leadership, but I'm afraid it's going to start with some legal reform. You simply can't have 95 out of 100 patents that go to the Federal Circuit on validity struck down. You know, you just can't. I remember going to the IP High Court, and they were worried about a 70% invalidity rate. We just have too many of the really savvy people in the world say we'll invest elsewhere.
And I think that's it. I think we are out of time. I think all of us will be around if anyone else has any questions, and thank you.